Nature, scope and evolution of administrative law. Introduction. Administrative law is a branch, part, of public law. It deals with the structure, powers, functions, and duties of administrative authorities, along with the remedies available to individuals when their rights are infringed by such authorities. Object. It ensures that administrative actions are legal, fair, and not arbitrary. Public law and administrative law. Public law. Public law means the branch of law that governs the relationship between the state and individuals. It deals with matters like constitutional law, administrative law, and criminal law, ensuring that government power is exercised properly and citizens' rights are protected. Administrative law. Administrative law is the branch of public law that governs how government agencies and administrative authorities exercise their powers, ensuring their actions remain lawful, fair, and accountable. It provides the legal framework for public administration and protects citizens against misuse of executive power. Transformation of laissez-faire to social state. In the modern era, the state has transformed from a laissez-faire police state into a social welfare state. Laissez-faire police state was a state whose primary job was only external defense and maintaining law and order. Social welfare state. It is a modern concept where the state actively promotes social and economic welfare. It impacts almost every sphere of life, from cradle to grave: education, health, transport, employment, housing, and social security. The idea is that the state should ensure justice, equality, and dignity for all citizens. Earlier, state equals laissez-faire, limited to defense plus law and order. Now, state equals social welfare, ensuring welfare from cradle to grave. Definitions of administrative law. Different jurists have defined administrative law based on their perspectives. Sir Ivor Jennings. Administrative law is the law relating to the administration. It determines the organization, powers and duties of administrative authorities. Note: this is widely accepted, though it does not explicitly mention the remedies available to individuals. Prof. K.C. Davis. Administrative law is the law concerning the powers and procedures of administrative agencies, including rule-making, adjudication, and enforcement. Prof. Wade. Administrative law is concerned with the control of governmental power to ensure that public authorities keep within their legal boundaries. Indian perspective. It is that branch of public law which controls the exercise of governmental power and provides remedies against its misuse. Object. It ensures that administrative actions are legal, fair, and not arbitrary. It prevents misuse of power and protects citizen rights.